Hello and welcome to Courts Today by Live Law. Let us get to today's top headlines. The Supreme Court has directed status quo on the property claimed by Uttar Pradesh MLA Abbas Ansari but declared as evacuee property. Rajiv Gandhi National University of Law Patiala's registrar has been suspended over allegations of sexual harassment and financial irregularities. The apex court has held that improper rejection of juvenility claim, even in Supreme Court's curative jurisdiction, is not final and fresh plea can be raised. The Supreme Court has granted interim relief to Telugu actor Mohan Babu, who said that he is ready to apologize and compensate in the case against assaulting a journalist. The Supreme Court has granted bail to Tihar jail's ex-deputy superintendent in a murder case of an inmate in judicial custody. The Supreme Court has sought a report from the Union on virtual hearing facilities at tribunals across the country. The Chandigarh Union Territory Administration has told the Punjab and Haryana High Court that show cause notice has been issued to Diljit Dosanjh, concert organizer, for breaching the noise limits. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before we move ahead, let me tell you, Live Law Academy is offering a value-packed opportunity for the aspiring judges out there. I am talking about the Judicial Service Examinations Preparation course. This comprehensive online course is specifically designed to help you prepare for your judiciary exams. The classes are conducted by expert faculty, including retired judges. You would learn from actual case studies and other easy-to-follow study material, and all of this at an affordable fee. So if you are gearing up for the judiciary exams, this is a must-check opportunity. Enroll today and get 20% scholarship. Only 3 days are remaining to avail the scholarship. You can check all details at www.livelawacademy.com. In a relief to Uttar Pradesh MLA Abbas Ansari, the Supreme Court has ordered status quo on a property that he claims ownership of. The property came to be bequeathed on Abbas Ansari and his brother through a registered will. In the year 2020, the SDM of Lucknow allegedly passed an ex parte order declaring the plot an evacuee property or government property. In 2023, the Ansari brothers were dispossessed from the property. They first approached the Allahabad High Court, but when the court did not grant an interim stay and construction began at the site, they moved to the Supreme Court in 2024. The Supreme Court had disposed of their petition in October last year, asking the High Court to hear the case on priority, with a final hearing set for 11th November 2024. But so far, the High Court has not taken up this matter. The court was today informed that 6 dates had gone by without any effective hearing before the High Court, and all other plot holders had got stay. Abbas Ansari's counsel, senior advocate Kapil Sibal, argued that authorities are continuing construction at the disputed site, and he claimed that only Ansari is being denied relief due to his background. While the allegation regarding Ansari's background affecting the High Court did not weigh with the bench, Justice Kant expressed concern about functioning of the Allahabad High Court, highlighting issues like collapsed filing and listing systems, which make it uncertain when the cases will be heard, despite the court being the largest in India. In the next update, the registrar of Rajiv Gandhi National University of Law Patiala has been suspended due to allegations of sexual harassment, academic and administrative misconduct, and financial irregularities. The suspension order noted that his wife has filed a cruelty complaint which is currently pending in court. This is because he allegedly married another woman who is teaching at the university. The order also mentions of an assistant professor's complaint of sexual harassment against him, for which an internal complaint committee was set up. The matter had reached the Punjab and Haryana High Court also, which had ruled in favor of the complainant, directing the registrar to pay a compensation of 3 lakhs. In addition to the sexual harassment allegations, the registrar is accused of financial misconduct, including abusing his official position for personal benefits and misusing the university resources during his tenure as both the registrar and officiating vice-chancellor. It was also revealed that he received the salary of vice-chancellor while holding the position of officiating VC. The apex court has ruled that if a plea of juvenility was not properly considered by the courts, it is not final. This means the accused can raise a fresh plea if the previous claim of being a minor at the time of the offence was not correctly addressed. A bench of Justices M.M. Soundaresh and Arvind Kumar was considering the case of an appellant sentenced to death for a murder committed in the year 1994. He claimed he was a minor at the time when the crime was committed, but the trial court ruled him as an adult, a decision which was later upheld by the High Court and the Supreme Court. He filed a curative petition in the Supreme Court presenting a school certificate that showed that he was 14 years old at the time of the crime, and the state of Uttarakhand confirmed this. However, the curative petition was dismissed. Then in 2012, the president commuted his death sentence to life imprisonment with the condition that he should not be released until he turns 60 years old. Further, in 2019, he filed a writ petition in the High Court of Uttarakhand challenging the presidential order and raising a new plea of juvenility. The High Court dismissed his petition, citing limited scope of judicial review over presidential orders. Appealing this decision, the appellant reached the top court again now. The Supreme Court observed that the earlier dismissal of the appellant's juvenility claim should not prevent it from being reconsidered, as the issue was not properly adjudicated. The court pointed out that the procedural requirement of Section 9, subsection 2 of Juvenile Justice Act of 2015 were not followed. It also noted the statement recorded under Section 313 of the CRPC could not be relied upon, especially since the appellant was asked to provide his personal details for the purpose of recording the statement. The court highlighted that the statement indicated that he was 20 years old at the time of deposition, suggesting he was 14 when the offence occurred. Therefore, the top court has now accepted his plea of juvenility. The court has said that dismissal of juvenility claim, even in curative proceedings, does not bar raising a fresh claim as long as the procedural requirements are followed. In another update, the Supreme Court has granted interim relief to Telugu actor Mohan Babu, directing that no coercive action be taken against him in a case where he is accused of assaulting a journalist. Let me tell you, the allegation is that Babu allegedly threw a wireless mic at a TV9 journalist, causing serious injuries to him. The Supreme Court bench, comprising Justices Sudhanshu Dholia and Prashant Kumar Mishra, issued a notice in response to a special leave petition filed by Babu. The petition challenges the Telangana High Court's ruling from last month, which had denied him anticipatory bail. The High Court had actually noted the grievous nature of the journalist's injuries and the claim that Babu attempted to influence the complainant to withdraw the complaint. Representing Babu before the Supreme Court, senior advocate Mukul Rohtagi explained that the incident occurred during a heated dispute with Babu's estranged son, who allegedly entered his house with a media crew. Rohtagi clarified that Babu threw the mic in the heat of the moment, and Babu is willing to apologize publicly and compensate the journalist if necessary. Rohtagi also mentioned that Babu had visited the journalist at the hospital to express his sorrow. However, the counsel representing the journalist countered the argument, stating that Babu's hospital visit was to threaten the journalist into withdrawing his complaint. The counsel also highlighted the severity of the journalist's injuries, which required surgery and extended hospitalization. Rohtagi then responded, saying that this was an unfortunate scuffle, not an attempted to murder, and that Babu had not intended to harm anyone. He emphasized that Babu is a well-known actor and the incident occurred in the heat of the moment when a large group barged into his house. Well, after hearing both the sides, the court has asked the journalist's counsel to consult with the journalist on whether he would accept compensation. And now let me tell you, the Supreme Court has granted bail to Narendra Meena, the former deputy superintendent of Tihar jail, in connection with the death of under-trial prisoner Ankit Gujjar, a 29-year-old gangster. The court set aside the Delhi High Court's order that had denied him bail. Gujjar was found dead in Tihar jail on 4th August 2021, and it was alleged that Meena and other jail officials had beaten Gujjar the day before and failed to provide him with medical attention, leading to his death. It was also claimed that the accused were extorting money from Gujjar's family. In response to the incident, 4 jail officials, including Meena, were suspended. Meena was charged for culpable homicide not amounting to murder and voluntarily causing hurt under the IPC. Also, let me tell you, the probe was transferred to the CBI after a plea by Gujjar's mother. Meena had approached the Delhi High Court for bail, citing delays in the trial by the CBI. However, the Delhi High Court had denied him bail in September last year, citing the serious nature of the offence and the possibility of him influencing witnesses or tampering with evidence. The High Court had observed that the post-mortem report showed multiple injuries on Gujjar's body. It emphasized that the larger societal interest should outweigh the accused's liberty in such cases. The Supreme Court has asked the Union government to report on the availability of video conferencing for lawyers and litigants in tribunals. While the high courts in our country are providing VC facilities, there is a need for similar access in tribunals to ensure convenience for all. A bench of Justices Rishikesh Roy and S.V.N. Bhatti of the Supreme Court was dealing with petitions regarding virtual access not being provided across all high courts and tribunals in the country. One of these petitions was filed against the Registrar General of the Punjab and Haryana High Court, alleging that the High Court discontinued the option of virtual hearing, which was made available during the COVID pandemic period. But now, considering a submission from the petitioner in person and Senior Advocate Nidhesh Gupta for the High Court that the facility has been made available now, the court dismissed this petition as withdrawn. The court noted that while video conferencing and hybrid participation had been ordered for forums like APTEL, similar facilities were not being provided by central and state electricity regulatory commissions, despite consumers playing a significant role. It was highlighted that compliance with the court's previous orders was limited to bodies like CAT, NCLAT and NCDRC and not fully extended to electricity commissions. Senior Advocate K. Parameshwar, acting as amicus, supported these concerns, emphasizing the lack of nationwide compliance by the regulatory commissions. Interestingly, Senior Advocate V. Giri, representing a woman advocate, highlighted to the court that provision of VC facilities had been a boon for women during and around the time of pregnancy. The court agreed and has now sought report from Union on virtual hearing facilities at tribunals. And lastly, the Punjab and Haryana High Court has disposed of a PIL regarding noise pollution during a concert by Punjabi singer Diljit Dosanjh in Chandigarh last month. The court noted that the Union Territory Administration had issued a show cause notice to the event organizers for breaching noise limits. The PIL here, filed by a resident, had sought directions to the administration to manage noise pollution, traffic and crowd control for the event. The court was informed that the noise level exceeded the 75 decibels limit set by the court when granting permission for this concert. The administration has issued a show cause notice to the organizers on 2nd January seeking an explanation for the breach and possible action under Environment Protection Act. The court observed that the administration had taken appropriate steps in response to the breach and the matter was being pursued according to law. The court then closed the proceedings of the PIL. In a light-hearted comment, the court jokingly remarked to the petitioner about a Coldplay concert in Ahmedabad and advised him to file a plea there as well. The court also noted the rapid sales of Coldplay tickets in India, where 150,000 tickets sold in just 4 seconds. If you want any more information on the cases that I mentioned here, you can visit our website at www.livelaw.in. Your support means the world to us. So dear viewers, please do not forget to like, share and subscribe to our channel.